When you are arrested and you bond out of jail and for a DWI, driving while impaired charge in the state of North Carolina, you will get a court date, immediately get a lawyer. While the facts are still fresh in your memory, you should write them down, get them out, just so if the case goes on a little longer, you are writing down everything that is important. While the facts are still fresh in your memory, you should write them down. This is helpful to the lawyer because in my case, I look at a checklist of things. I look at to see if the officer had reasonable suspicion to stop your vehicle. If it's a motor vehicle, golf cart, whatever motorized vehicle. I look to see that there's probable cause. That is, did the officer have what's called probable cause to arrest you? And then we look at other things. If you took the breathalyzer, we look at the machine, the ECR2 currently, to see if it's calibrated. There's certain things to look at to see if it's admissible in evidence, because the way that the state of North Carolina would get a conviction is to either show evidence that you were what's called appreciably or noticeably impaired, that's the state of the law, that you're noticeably impaired, or that you have an alcohol content of 0.08 or more. And the 0.08 they show usually with a properly admitted breathalyzer test, or if you don't do that and they get a search warrant and they get a blood test and that blood test comes back as a 0.08 or more, they'll try to introduce the blood test into evidence. So that's how in the state of North Carolina prosecutors present evidence on DWIs. After the state presents its case, then the defense can either present witnesses if needed, or the defense, depending on what the defense is, the defense may be just cross-examination of the various witnesses, pointing out all the things that they did wrong, putting reasonable doubt into the juror's mind, into the judge's mind, depending on if it's a bench trial or a jury trial. But basically it is holding the state's feet to the fire. They have the burden of proof. You don't have to prove anything. And so if they have not done their job, then it should be a not guilty verdict. And that's what a good lawyer does, is prepare, look at the facts of the case, see what is missing, see what they did wrong, all of those to analyze what the best defense might be.